Okay, so we're going to get started this afternoon. Hello and welcome to the Landlord Self-Help Center's Landlord Lunch and Learn session. My name is Ashley and I am a community legal worker and paralegal. My colleague Catherine is also going to be presenting today. The Landlord Self-Help Center is a community legal clinic funded by Legal Aid Ontario. The Landlord Self-Help Center was founded in 1975 and incorporated in 1977. We have a province-wide mandate to support the small-scale landlord community. Approximately 80% of the Landlord Self-Help Center's resources are dedicated to client services. This Landlord Lunch and Learn session will focus on representation at the Landlord and Tenant Board hearing. The information offered in the presentation is intended as general information. It is not legal advice. We will have a question and answer period at the end of this presentation. We will answer questions in regards to the current Lunch and Learn topic of self-representation at the Landlord and Tenant Board hearing. At the Landlord Self-Help Center, we acknowledge the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit and the Williams Treaties, signed with multiple Mississaugas and Chippewa bands. As a community legal clinic funded by Legal Aid Ontario with a province-wide mandate, we acknowledge that there are 46 treaties and other agreements that cover the territory now called Ontario, and we make this acknowledgement in support of the necessary work of reconciliation. Residential Tenancies Act. The Residential Tenancies Act is Ontario legislation that governs residential tenancies and matters related to renting in Ontario. It is commonly referred to as the RTA. The RTA was created in 2006. It establishes laws for landlord-tenant obligations, rent increases, and the grounds for termination of tenancies. The Landlord-Tenant Board. The Landlord and Tenant Board, also known as the LTB, resolves disputes between residential landlords and tenants, eviction applications filed by nonprofit housing cooperatives. The Landlord and Tenant Board also provides information about its practices and procedures and the rights and responsibilities of landlords and tenants under the Residential Tenancies Act. You can find the Landlord and Tenant Board's website by visiting tribunalsontario.ca/LTB.
Why involve the Landlord-Tenant Board? Unfortunately, a landlord may find themselves in a situation with a tenant that requires them to commence a legal proceeding. This will be brought forth by way of application to the Landlord-Tenant Board. An application through the Landlord-Tenant Board is the only way to obtain a legally binding eviction order for a tenant. It is also the only way to obtain a legally binding order for repayment of rent arrears or a legally binding order for the tenant to cease unwanted behavior. Statistically speaking, according to the Landlord-Tenant Board's 2022-2023 business report, there was 37,690 applications for eviction for non-payment of rent, which is an L1 application, versus 15,354 applications for other reasons, which is an L2 application. Landlord-Tenant Board notice of evictions. Before a landlord can file an L1 or an L2 application with the Landlord-Tenant Board for eviction, the landlord must serve a notice to the tenant using one of the prescribed forms. These forms include the N4, notice to end your tenancy early for non-payment of rent. The N5, notice to end your tenancy for interfering with others, damage, or overcrowding. An N6, notice to end your tenancy for illegal acts or misrepresenting income in a rent geared to income rental unit. And 7, notice to end your tenancy for causing serious problems in the rental unit or residential complex. And 8, notice to end your tenancy at the end of the term. And 12, notice to end your tenancy because the landlord, a purchaser, or a family member requires the rental unit. And 13, notice to end your tenancy because the landlord wants to demolish the rental unit, repair it, or convert it to another use. It is important to note that an application for eviction has to fall under one of the reasons listed above. A landlord cannot apply for an eviction of a tenant if their situation does not fall under one of these examples. Preparing notice. The notice is not only the first step towards a landlord-tenant board application, but it is also the most important. I'm sure many of you have heard horror stories of a landlord waiting 6 months for a hearing only to have it be dismissed based on a fatal error on the notice. This is why it is so important to make sure that your notice is error-free. All notices look similar to the one on the screen and have an area to fill out the tenant's name, landlord's name, address, and termination date. The example you see here is an N4, notice for non-payment of rent. While filling out the tenant name section, it is critical that each tenant is listed. The tenant's names must be written down as their full legal name, free of any spelling errors. If there are other people living in the rental unit, such as occupants or minors, do not include those names on your notices. When filling out the address of the rental unit section, the address must be correct, including the postal code, and it must also be free of spelling errors. It is critical that if there is a unit number or room number to the rental address, that it is included under this section. Not correctly identifying, such as the fact that it's a basement unit, is one of the most common reasons why an application could get dismissed. Next is calculating the termination date. Each notice will have a determined amount of days you have to provide to the tenant to vacate, which will be how you determine the termination date you put on the notice. In the example of N4, the tenant is meant to pay the rent that they owe or move out within 14 days. So let's say you serve the tenant with an N4 notice today, being September 18th. You start counting the 14 days the day after you serve the notice, which makes September 19th day 1. You count every single calendar day, including weekends and holidays. This brings the 14 days to October 2nd, which would become the termination date. Serving the notice. Once the notice is complete, the next step is to provide it to the tenant. This is considered serving the notice. The Landlord-Tenant Board has rules of serving, which means the notice can only be served in one of the following ways: handing the document to the person, handing the document to an adult person in the tenant rental unit, leaving the document in the mailbox or a place where mail is normally delivered, placing the document under the door of the rental unit or through a mail slot in the door, sending the document by courier to the person, sending the document by mail or express post to the last known address of the person, sending the document by email. It is important to note that if you're serving the notice via mail, you must add 5 days onto the termination date to account for the time it takes for the mail to be delivered. Also, you can only send notices to your tenant via email if you and your tenant have consented to receive notices via email, rather on the lease agreement or by executing the consent to service by email form. Certificate of service. Once you've served the notice to your tenant, you must complete the form that is called the Certificate of Service, which is now shown on the screen. The certificate of service is essentially a legal document proving that you did in fact serve your tenant. It is important to make sure that this form is also completed correctly. You will see the address gets filled out on the top of the form. Directly underneath that, you see an I followed by a blank space. This is where you would put your name or the name of the person who served the form. The date beside that is the date that you served the form to the tenant. You must also fill out the other spaces, which include the type of notice or document you served, who you served it to, and how you served it. The application. Once the notice has been served to the tenant, the next step is filling out the application with the landlord-tenant board. It is important to note that the notice you provided to your tenant will determine the wait time, if any, between serving the notice and when you can submit your application with the landlord-tenant board. Using the previous example of an N4 notice that was served on September 18th, the earliest an L1 application can be filed is October 3rd. This is because the tenant had 14 days to pay their arrears or move out, which would have voided the notice. On the screen, you will see a screenshot of the Tribunal Ontario online portal. This method is the Landlord-Tenant Board's preferred method of filing and is also, in my opinion, the easiest way to file for those who have access to a computer and the internet. While you go through the application, rather over the portal or over the forms, it will ask you required information unique to the specific notice that you served. Unlike filing your application using the forms, the portal will provide you with prompts like the one you see on the screen. This prompt is advising that you must include mandatory documents within 5 days of filing the application, or your application may be dismissed. Documents that are mandatory depend on the specific application, but one thing that you must always submit with every application is the notice of termination and the certificate of service. You can see on the screen when using the portal that you are able to upload your documents at the time of filing. If you choose to use any other method to file, you will have to ensure that the mandatory documents are included with your application. There are many different methods for filing an application. You've just seen screenshots of the Tribunals Ontario portal, which you can use for L1, L2, L3, L4, and L10 applications. You can also email your applications and pay for applications using the Tribunal's online payment service if you're filing an L5, L6, L7, L8, A1, A2, and A4 application. All applications can be couriered to the main mailing address of the LTB, which is 15 Governor Street, ground floor in Toronto. You can also send via regular mail through Canada Post to the address of the LTB office that is closest to you. There are some Service Ontario centers that accept all landlord and tenant board applications in person. You'll have to go on the Service Ontario website listed below to determine which Service Ontario location is available close to you for accepting these applications. Be prepared at the time of filing to pay the application fee or the cost of filing, which is $186 on the portal, or $201 if you're deciding to use other methods.
Notice of hearing. A notice of hearing is a document sent to both parties by the Landlord and Tenant Board once a hearing has been scheduled. It will be sent to the parties via regular mail or email. It will also be available on the Tribunals Ontario portal. The notice of hearing package is approximately 3 pages long. The first page will contain the file number, parties to the application, the address of the rental unit, the date and time of the hearing, the Zoom link to log on via Zoom, the telephone number and meeting ID if you need to call in. This is an example of what the first page of a notice of hearing will contain. At the top, you will see the file number. This is very important as each case has its own unique file number. It will begin with LTBL for landlord applications or LTBT for tenant applications. It will also list the parties to the application. It will list the applicant, who is the person that has filed the application, and the respondent, which is the person who has been filed against. It will list the rental unit address that is being discussed at the landlord-tenant board. It will also list the hearing type, hearing date, hearing time, and hearing location. You can join the virtual hearing using the unique Zoom link that has been provided to you on your notice of hearing. If you need to call in, they also provide a toll-free or local number, and you will have a unique meeting ID number that you will use once you have called in. The other 2 pages of the notice of hearing document explain hearing etiquette and where to find legal assistance for both landlords and tenants. Preparing for the hearing. The best way that we think to prepare for a hearing would be to watch other landlord and tenant board hearings to understand the general process involved. You can request hearing links directly from the landlord and tenant board via email, which is ltb@ontario.ca. Prior to the hearing, you should review your notices of termination, all calculations, and all allegations. You should be prepared to speak to the notices that you have served the tenant and the applications that you have filed. If you have filed served your tenant with an N4 notice and filed an L1 application, you will need to submit an information update sheet at least 5 days before the hearing. This information update sheet should be filled out and put onto the landlord and tenant board portal. It should also be served directly to the tenant. Evidence. Evidence must be served at least 7 days before the hearing date. It should be uploaded to the Tribunals Ontario portal and served to all parties. If you only wish to upload your evidence to the Tribunals portal Ontario, you would need to have an agreement in writing from both yourself and the tenant to accept service through the portal. The parties would need to use the consent to disclosure through Tribunals Ontario portal form for such an agreement. Otherwise, it needs to be sent directly to the tenant. The Landlord-Tenant Board has Rule 19, Disclosure and Evidence. It also has a practice direction on evidence. So standards required for submission of evidence are all documents, photographs, and other items provided to the other parties and the Landlord-Tenant Board as evidence must be readable, have consecutively numbered pages, and include a list or table of contents identifying each item in order by page number if more than one item has been submitted. The preferred standard of document submission is PDF. However, other standards or formats are fine as long as the above criteria of the page numbers and table of content has been met. Witnesses. You may have a witness attend at your hearing to provide evidence and testimony. Witnesses should not be in the hearing room while the hearing is ongoing. Make sure you highlight any witnesses you may have so that they can be moved. During the hearing, you will attend a sign-in process, which I will speak about a bit later, but witnesses should identify themselves at this sign-in with the file number and rental unit address so that they can be properly identified. If you have a witness who does not wish to or cannot attend, you can request that the Landlord and Tenant Board issue a summons. If the board issues the summons, it must be handed directly to the witness. You must also pay a witness fee. Witnesses should be prepared to spend the entire day at the hearing. The hearing. At the hearing, a moderator or member, also known as an adjudicator, will sign the parties in. You will need to have your file number readily available, as well as your name, what you are to the application, which should be landlord, and the rental unit address. Once you have been signed in, you may remain on mute until your matter is called. You should also turn off your video unless otherwise instructed by a moderator or member. On a landlord application, the landlord will proceed first. On a tenant application, the tenant will proceed first. When it comes to how the hearing itself will proceed, each adjudicator has their own unique style, so individual hearings may look a little different from one another, but generally the process will be as follows. Direct examination. This is where a party will explain their side of the case. This can be done by verbal testimony and/or questioning witnesses. It will also include the presentation of evidence. Cross-examination. This is the opportunity for the other party to ask questions of the person who has just provided the direct examination. Redirect. This is a chance for the party who has given their direct examination to clarify anything that may have come up in the cross-exam. Closing. Closing, this is the opportunity for a party to let the board member know what they are seeking. A landlord is typically seeking an eviction and potentially arrears or damages. Mediation. Mediation is an opportunity to discuss all issues and try to come to a resolution. It is a private and confidential agreement between the parties. What was discussed in mediation cannot be brought up at a hearing if the issues were not resolved. All parties must consent to mediation. Some landlord and tenant board hearing blocks will have dispute resolution officers, otherwise known as DRO, available to assist the parties in mediation. During the sign-in process, the member or moderator will ask you if you are interested in mediation. You may say yes at this point. If both parties have agreed, they will mark you as consenting to mediation, and you will be put into a breakout room with a dispute resolution officer at the earliest opportunity. Some hearing blocks do not have dispute resolution officers available. If that is the case, you may wish to consent to have a private conversation. During this private conversation, if you and the tenant reach a resolution, you can go back into the hearing room and present this as a consent order. A consent order means that both parties have come up with an agreement that they are happy with, and the adjudicator will listen to your consent and write an official order stating the terms.
The following slides are going to discuss sections of the Residential Tenancies Act that a landlord who decides to self-represent themselves may not be aware of, and how this part of the law could affect your application. On the slides, you'll see the verbiage used in the Act, but I'm going to try to explain them in layman's terms. Section 78. Section 78 is a clause that could be a part of your order. You will most often see this type of clause if you and your tenant came to a mutual agreement during mediation, or if the adjudicator decided that the tenant is able to remedy the situation and avoid eviction. In the case of an L1 non-payment for rent application, this would be a payment plan towards arrears. For example, the tenant may be ordered to pay their rent on time and $1,000 each month towards their arrears. This portion of the order would be subjected to Section 78. This means that if your tenant fails to comply with the payment schedule, then you as the landlord can apply to the board with an L4 application. An L4 application would result in an order for eviction without a second hearing had to be held. Section 82. Section 82 applies if your application is on the basis of non-payment of rent, rather an L1, L9, or L2. Essentially, a tenant is allowed to seek offsets of their rent arrears for any reason that could provide them with a monetary remedy under any of the tenant applications. A tenant does have to provide notice to the landlord if they intend to bring up Section 82 issues 7 days prior to the hearing. The limitation period of 1 year also applies, meaning if the tenant is trying to claim compensation for an issue that was resolved over 1 year ago, it will not be allowed. There is general understanding that a tenant is not allowed to withhold rent, which for the most part is true. However, Section 82 claims can be successful. For an example of when a tenant may receive an offset to their arrears is if the landlord illegally increased the rent, the tenant continued to pay the rent amount prior to the illegal increase, and the landlord pursued an application for the amount of arrears that accumulated based on the fact that the tenant was not paying the illegal increase amount. Another example could be if the landlord failed to comply with their maintenance obligations in a timely manner. Say the fridge in the unit broke down, and because the landlord did not act quickly enough, the tenants paid out of pocket to replace the fridge. The next month, the tenant remitted payment of rent minus the amount that they cost to replace the fridge. Section 83. Section 83 gives power to the board to delay or deny an eviction. There are certain circumstances where the board member must choose to deny an eviction, which include A, the landlord is in serious breach of the landlord's responsibilities under the Residential Tenancies Act or any material covenant in the tenancy agreement. B, the reason for the application being brought is that the tenant has complained to a government authority of a landlord's violation of a law dealing with health, safety, housing, or maintenance standards. C, the reason for the application being brought is that the tenant has attempted to secure or enforce his or her legal rights. D, the reason for the application being brought is that the tenant is a member of a tenants association or is attempting to organize such an association. Or E, the reason for the application being brought is that the rental unit is occupied by children and the occupation by the children does not constitute as overcrowding. The board, however, can delay an eviction for any reason if they feel that there is prejudice to the tenant. These type of reasons may include if the tenants have been there for a very long time, if there are children who reside in the unit, if the tenant is temporarily unemployed, or suffering from some sort of illness. Although Section 83 does not outline the prescribed time to delay an eviction, what we usually see in practice is the eviction order being pushed back to a 60-day notice rather than the standard order 11-day eviction.
The order. After your landlord and tenant board hearing, an adjudicator or member will typically reserve their decision. What this means is that you will not know the outcome of your hearing on the hearing date. The adjudicator will provide their decision in an order. An order is the written decision of the adjudicator who heard the matter. It will provide the reasoning for the decisions. The order will be sent to the parties in the same way that the notice of hearing was sent to them, regular mail or email. It will also be available on the Tribunal's Ontario portal. When logging in to the Tribunal's Ontario portal, you will have the option to see the status of your hearing. Typically, it will say pending and then closed once an order has been issued. An order is typically issued within 60 days of the hearing. Enforcing payment. To enforce payment, you must file your landlord and tenant board order with the small claims court for garnishment. The garnishment must be filed in the court that has jurisdiction over the area where the debtor resides or carries on business. It can be filed online via the small claims court portal. The Small Claims Court has a guide to procedures after judgment, which can be found on their website at ontario.ca. Request to review. A request to review must be filed within 30 days of the issuing of the Landlord and Tenant Board order. It can only be filed for a serious error and/or if a party was unable to reasonably participate in the hearing. It costs $58 to file a request for review.
Self-representation versus hiring a paralegal. This is a question that we get asked all the time is, do I need to hire a paralegal? There are some pros to self-representing yourself, that being that the Landlord-Tenant Board is actually designed to have self-represented parties. You will know the facts better than your representative because you're the one directly affected by the reason why you are trying to seek an eviction with your tenant. And it also saves costs. Paralegals can be rather expensive. When it comes to the pros of hiring a paralegal, they will have a better understanding of the law, especially sections that I discussed, like the Section 82, Section 83 issues. It will also save you the time and stress of doing the paperwork. The notices, the service, the application can be stressful to some people. And it's going to provide you with a sense of ease at the hearing, knowing that you do have arguably a seasoned professional there with you. For those who do decide to self-represent themselves, I'd like to point out some of the resources that are available to you. On the Landlord Self-Help Center website, which is www.landlordselfhelp.com, we have a number of landlord learning modules that will go over the different notices and applications. Same with our Sound Advice for Landlords podcasts and our frequently asked questions. We also have a Facebook page, which is Landlord Self-Help, and a YouTube channel, which is at Landlord Self-Help Center 7429. You can also find a number of resources on the Landlord Tenant Board's website. There's practice directions and interpretation guidelines for many specific issues that I highly recommend reading. There is the Navigate Tribunals Ontario demo, which may give you some insight into what application it is that you're trying to file, and some information on the different rules. An important one, which Ashley also mentioned, was Rule 19, disclosure and evidence. Lastly, for those who may have decided that they would like to hire somebody to represent them, there is the Law Society Referral Service, which is www.findlegalhelp.ca, where you'll be offered free 30-minute consultations with different paralegals who practice under the RTA and in front of the Landlord Tenant Board. That concludes the presentation portion of this Landlord Lunch and Learn series. Before we move on to the Q&A period, I would just like to remind everyone we are doing our final Landlord Lunch and Learn series for this year on November 13th at 1 p.m. It's going to be about filing with the sheriff and what to expect.
Thank you very much, Catherine and Ashley, for your presentation. And yeah, one of the things I meant to say at the beginning of the presentation is to save your questions for our Q&A period. And the questions need to be related to this presentation. If anyone has any questions related to their own situation, then we definitely welcome everyone to contact us during our office hours and we can answer the questions then. Um, we previously received a couple of questions, so we'll go through those questions while we give some time to our participants today to ask their questions. Um, so one of the questions previously received says, we are trying to evict a tenant for landlord's own use, but the tenant has also damaged the house and has not paid rent for 8 months. The client that sent this question is wondering, can can I include that in the hearing? Catherine, would you like to answer that question, please?
Yeah, of course. So personal use would be a N12 notice followed by an L2 application. So at your hearing at the landlord tenant board, they're only going to listen to the merits of your N12, meaning the fact that you actually want to move into the unit. Arrears would be a separate L1 application, and damages would be a separate L2 application, provided that you served rather the N4 or N5 notice. In the event that a landlord has multiple reasons for eviction, they can request to the landlord tenant board that their applications are merged. However, when it's a personal use application, I would not recommend merging any other application with it.
Yeah, I think that's a very important tip for self-representation to really focus on the application at hand. If they the issue that they're encountering, it's not already included in that application, then it's better not to mention it as you're not able to do that. We have another question that we previously received, and it says the following. It has been more than 60 days since my hearing, and the LTB has still not issued an order. What can I do? Ashley, would you like to answer that?
Yep. So if it has been more than 60 days since your hearing and you still have not received an order, you can email the Landlord and Tenant Board directly at ltb@ontario.ca with your file number and the date of the hearing to ask for an update on the status of the file. You may also wish to file a complaint with the Ombudsman's office. And you can also check the status directly on the portal. As I mentioned earlier, it will say pending if there's no order issued yet. If you wish to file a complaint, the Landlord and Tenant Board does have a complaint policy, which can be found on their website, which is tribunalsontario.ca.
Okay, thank you so much, Ashley. So we're going to answer the following question from the Q&A period. The one of the clients is asking, if the tenant has not paid rent since April 2024, I submitted the forms and the tenant did get legal counsel and submitted issues for maintenance and asked for a rent abatement, but the tenant never gave notice of these issues to the landlord. Um, can Catherine please explain why this would be the case?
Yeah, so I'm going to try my best to answer. At, when it's a tenant who brings forth their own application, there is no notice required to be given, like, as the landlord has to give rather an N4 notice or an N5 notice. If this was a Section 82 situation, you could have brought up the fact that your tenant never provided notice. And what could have happened was the adjudicator could have adjourned the hearing so that you had time to prepare to defend the Section 82 questions, or the adjudicator could have decided to not allow them at all. Oftentimes, if the other party doesn't bring up the issue that things weren't disclosed properly, the landlord tenant board will just proceed with the merits that are trying to be raised.
Okay, thank you so much, Catherine. Somebody's asking if you could please send the list of evidence requirements and how to submit evidence. This was discussed during the presentation, so just so everyone knows, the presentation is being recorded and the recording will be available on the Landlord Self-Help Center's website. So you can rewatch and listen to the list of evidence requirements. Then everyone will get a notification as to when the recording is available. But if Ashley, would you like to go over just the evidence requirements?
Yeah, I can go over them again. And also, it is available on the Landlord and Tenant Board website, which is tribunalsontario.ca. It's under the practice direction for evidence. So it's not under the rules. It is under the practice direction. Let me just find my notes. So when you're submitting evidence to the Landlord and Tenant Board, it needs to be readable, have consecutively numbered pages, and include a list or table of contents identifying each item in order and by page number if more than one item is being submitted. The preferred method is generally one PDF with all of the evidence merged with the page numbers and table of contents, but you can use other formats as long as those requirements are met.
Thank you so much, Ashley. Our next question is, should I restrict only names on the lease agreement, or should I include other adults residing in the property when serving notice? Catherine?
Yes. So the only names that should be put on the notice is the names of people who are actually your tenants, being the people that you have the lease agreement with. If there's other people who are residing on the property that haven't become tenants of yours, then do not include them on the notice.
Okay. Our next question says, please confirm if a residential property is owned by an incorporated company. The landlord cannot make a request for eviction for personal use. Correct or not? Ashley, would you like to answer that?
Yep. So you should definitely give our office a call because each circumstance can be slightly different. But generally, the answer is yes. A landlord who is a corporation cannot give a notice for personal use.
Okay. The next question says, I filed an L1 application with a landlord and tenant board. The tenants were apparently notified, and I received an email from the board for me to choose a hearing date. Do I choose the date or the LTB chooses the date? Catherine?
Yeah, most often you will receive a notice of hearing package that gives a date to you. I have been seeing recently where people file with the portal that they are provided with options of dates. So if you were one of those people, then you have the ability to choose your date. But in most cases, the landlord tenant board will just give you a date. If you did receive the option to choose a date, I would respond back to them to secure that you have gotten the date that you wanted.
Okay, thank you, Catherine. The next one says, the LTB has issued an eviction notice for non-payment of full rent, which the tenants have appealed. Stay order was issued with a hearing date. Can the tenants negotiate the mediated agreement terms in this hearing? Ashley, would you like to answer that?
So if it's a request for review at the landlord and tenant board, then yes, you can agree to mediation and come up with a consent agreement. If this is an appeal to divisional court, I wouldn't be able to speak to that process. I would recommend that you seek a lawyer who can give you some advice on that.
Thank you so much, Ashley. The next question says, during a specific hearing, does the board take into consideration the other issues against the tenant? For instance, if there is a variety of previous concerns such as bed bugs, smoke alarms, cleanliness, does it hold weight against the tenant when the landlord is dealing with multiple issues with the tenant? Catherine, would you like to answer that, please?
Yes. So pretty much no. I'm assuming in this situation, it was maybe an arrears application, and the landlord is hoping to bring up the fact that there's been also issues with like bed bugs, cleanliness problems. Um, your tenant can, have behavioral issues and not pay rent at the same time, but in front of the landlord tenant board, you have to have a specific application for both. So if the issue is concerns like cleanliness, maybe safety issues, if they've been meddling with the smoke alarms, um, you would have to file the appropriate notice, uh, which would be an N5, and followed with an L2 application. If you're also trying to get an eviction for arrears, that would be an N4 notice followed by an L1 application. If you have both problems with the same tenant, you can ask the landlord tenant board by request to merge the applications. And only if you were to file both applications and have them be merged, would you be able to bring up both issues at the same time. Otherwise, you're dealing with just the one issue pertaining to the notice and the application that you filed.
Thank you, Catherine. Um, our next question reads as follows. Tenants tend to communicate via text, and there is a lot of important information that may be important as evidence. Is text communication acceptable as evidence? And if so, what's the best way to produce these that would be acceptable to the landlord and tenant board? Ashley, would you like to answer that, please?
Yep, so text is definitely able to be used as evidence. The best way to get that is typically to screenshot the messages and then combine them into one document and add page numbers. So when you're at the hearing and you're calling attention to that text message, you would say, please go to the text from October 2nd, 2023 on page 6 of my evidence package. And that would direct the adjudicator to that text. And then you can read out the contents of the text, but those are definitely able to be submitted as evidence. If you can't put them all into one PDF document, then just make sure it's very clearly labeled, numbered, and titled.
Thank you so much, Ashley. Our next question says, when mailing a notice, in 5 days, notice is required or 7 days for evidence. Is it 5 or 7 calendar days or business days? What about holidays? Catherine, would you like to answer that, please?
Yeah, so there is a requirement to provide evidence to both the landlord tenant board and the tenant 7 days prior to the hearing. So if you intend to disclose your evidence to the tenant by mail, you would have to mail that evidence 5 days prior to the 7. So I guess the deadline becomes 12 for mailing evidence to the tenant. And these would be counted as calendar days. Even if, one of those days was on a stat holiday, it wouldn't count. It's calendar days. So weekends, stat holidays, etc.
Thank you so much, Catherine. Our next question asks, are audio recordings accepted? What has been your experience with use of these for evidence? Ashley, would you like to answer that, please?
Yep, so audio recordings would be acceptable. You would need to upload the file to the portal and make sure that it has a very specific name. So for example, October 2nd, 2023 audio recording, just so it's clearly labeled and everyone would have access on the portal. And then you also do have to send that audio recording to the tenant. And when you go through the audio recording, you should realize which parts are important. So if it's like a 20-minute recording, you'll want to narrow it down, say like go to 1 minute and 50 until 2 minutes and 12. just so it's easy for everyone to find the relevant bits, but they are acceptable. Ultimately, the adjudicator does have the final say of whether they hear the evidence and whether they accept the evidence, but if you've disclosed it in advance and it follows the evidence rules, I don't see why it wouldn't be admitted.
Thank you so much, Ashley. Okay, the next question says, if a tenant already moved out, but before moving, they submitted a T2 application and wanted a remuneration of $1,000 for landlord to pay for moving out, they do not have any receipt for moving. Is this a valid claim? They moved out because the landlord filed the L2 and tenant moved out because they purchased a house. Um, Catherine, would you like to answer that?
Um, I mean, this is a kind of question where I would say probably call the office because I have more questions about your questions to answer you correctly. But on a general basis, if a tenant moves out because of an L2, that doesn't give them the remedy of moving expenses. There's certain L2 applications that would require compensation have been paid to the tenant because of the notice that was given to them. Um, when tenants are filing T2 applications and seeking for moving expenses, it's really most of the time only rewarded if, you know, it was something of the tenant's actions that they did that was not within their legal rights, such as filing an L2, that forced the tenant to move out. So illegal locking them out, illegally coming into their unit, harassment to the point where the tenant felt that they had no other option but to leave. But by all means, to the person who asked that question, I would call our office and we can kind of discuss more about your specific case.
Yeah, definitely. That's why we really emphasize the fact that if you have a question about your own case, just to call. Because yeah, in order to provide accurate legal advice, it's just better to ask all the questions that our CLWs would have in order to answer that. The next question says, if a numbered company I own is on title and all leases only mention my name, is it true that for simplicity, I can continue just mentioning my name on an L1, L2, L5 forms? Ashley, would you like to answer that, please?
Yeah, so I mean, again, that would depend, and you should definitely give us a call to discuss the specific circumstances, but mostly the lease is paramount, so what's listed on the lease would be fine.
Thank you. The next one says, I have an L9 order, but the tenant has not paid. I want to serve the tenant an N4. Could I include the unpaid rent from the L9 order in the N4? Yeah, this sounds more like specific question. So we really need you to call our office. The next one asks, does the adjudicator read all the documents presented by the tenant and the response from the landlord prior to the hearing? Catherine, would you like to answer that?
Um, I wouldn't count on it. There are certainly, in my experience, some adjudicators who will prepare themselves more for the hearing by taking a look at whatever was submitted. But as a general rule, they're not required to do so. And the only thing that they can rely on while making their decision is what was submitted as evidence at the time of the hearing. So if you have included 20, email correspondences between yourself and the tenant, or vice versa, the only ones that can be considered in making the decision is the ones that got spoken to at the hearing.
Thank you so much, Catherine. The next question reads as follows. If the texts are blurry and unable to read in the evidence that the tenant submitted, what does the adjudicator do? Ashley, would you like to answer?
So it depends on the adjudicator because they do have that discretion, but generally they would ask for clarity and clarification on what's going on with the evidence. If it's totally being unable to be read, then it likely wouldn't be admitted. But if it's blurry and they can kind of make it out, they may have the tenant speak to it, or the person that sent the text can also speak to it. So if the tenant has a witness or something like that who sent that text, they could speak to that as well. So it would really depend on the exact circumstance. but generally they would ask for clarity and have the person who sent it read into the record what it actually says.
Thank you, Ashley. The next question reads as follows. Can you serve evidence by placing under the door, such as a document brief, or by directly handed it to the resident? Or if agreed to in the lease agreement, service by email, can you serve the document via email? Catherine, would you like to answer that?
When it comes to evidence, I always recommend being overly cautious. So I would say serve it by email and also provide them personal service or physical copy as well. Um, it's this whole email thing is still kind of new to the board, and adjudicators will make different decisions. Some may not accept your evidence if you have not uploaded a certificate of service to explain how you provided it to them. Others may only deny your evidence if the tenant raises an issue with it. So when it comes to the landlord tenant board, because the adjudicators have so much discretion, I always recommend following everything you gave to the tenant up with a certificate of service, and always backing it up with secondary service to an email.
Okay, thank you. The last question reads as follows. Do audio recordings need to be consented to? For example, if someone didn't know they were being recorded, is that allowed? Ashley, would you like to answer that?
So Ontario is a one-party consent province. However, the person that's recording does need to be a part of the conversation. So you can't just record a tenant talking with their family member in the hallway. That wouldn't be allowed. But if you're talking to the tenant yourself and you're recording that conversation, then that's fine. That's the general rule.
Thank you so much. And we'll just answer the last question that came through. If a tenant has not signed an agreement to communicate by email and the tenant sends emails, is the landlord obligated to respond to those emails? Catherine, would you like to answer that?
Generally, the consent to communicate via email goes both ways, landlord and tenant. Um, if you, at some point in time, your tenant has received your email address, so that may have been implied consent to receive emails from your tenant. I would be cautious of not responding if the situation was regarding like a maintenance request, or something that, as a landlord, you would have the duty to, act on. Again, that might be one that you should call into our office and we can kind of talk about that in more depth.
Yes, yeah, definitely can be complex to answer. And just, as a general reminder, if you're a self-represented party, we really advise landlords to observe hearings. I think Ashley and Catherine already mentioned during the presentation, but let's just, do a reminder. How can our clients reach out to the board and obtain the Zoom links so they can observe hearings? And that would be the best way to prepare themselves for their hearings.
Yep. So if you're looking to observe hearings, you can email the landlord and tenant board directly. Their email is ltb@ontario.ca. And in the subject line, you can just put hearing links. And in the body of the email, you just request the links for the hearings, and they will send those to you. And then you can click any of the links that they send, and you can find hearings that are related to what you're doing. So if you're doing an L1 application, you would look for the hearings labeled L1 in the links that they send out. You would click that and you can just observe all day. When you go to observe, change your name to observer before you enter, and then just remain on mute and have your video off unless you're requested to sign in by a moderator, in which case you would just say, I'm an observer.
Thank you so much, Ashley. So for those questions that we were not able to answer today, please contact our office during our business hours. And that concludes the Q&A period. And now we have the survey link. In order for our participants today to please fill out the survey and provide us with your feedback in order to improve our webinars. And thank you very much for watching.
Thank you all for attending.
Thank you, everybody. It was a pleasure.
Bye, everyone.
Bye.